So let's get started. Hi, everybody. Welcome to class. Today, we're going to dive deep into the 14th Amendment. We're going to be looking closely at the 14th Amendment from its first writing to modern day today. So it's battles for equality in America and really looking at these major court cases. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center, and I'm very excited for this topic because this is an amendment that I feel like we talk about all the time. And so one we really need to understand why they wrote it, what were the intentions of the writing, and then how it's used today. And we are joined by our top scholar at the National Constitution Center, Jeff Rosen. Jeff, would you like to say hi to everybody?
Well, hi, everyone. It's so great to see you. And boy, this is an important topic. I just can't wait to get started.
I can't either, Jeff. And there's so many questions around this topic. One, when did they write it? What were the intentions of writing it? How does it spell out the ideas of freedom and equality? And then how do we see it being interpreted and used today? That's just some of the big kind of goals that we want to achieve today, all in 30 minutes. I think we can do it. Would you like to dive deep into the amendment? And also, would you like to go to the interactive constitution? It's up to you.
That sounds great. Well, just starting with the text is, of course, the right place to start. And friends, the reason Kerry and I are so excited about today's class is because the 14th Amendment is so central to so many questions that are at the core of American life today. I teach constitutional law at GW Law School, and the entire class, the main class I teach, is about the 14th Amendment. So you can spend an entire term in law school parsing each of these important clauses. What we're going to do is get the big ideas today, and then hopefully you'll get excited and we'll want to learn more later. So let's begin with the text. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. So that's called the Citizenship Clause. And the big idea there is that if you are born or naturalized, that means that you're not originally a citizen, but you become one once you're already in the United States, then you're a citizen of the United States and the state where you live in. So everyone who is either born or naturalized in the United States is a citizen of the United States and of a particular state. Kerry and I are citizens of the United States and of Pennsylvania, where we reside. That's a huge idea because remember, the Dred Scott decision in 1857 said that free African Americans couldn't be citizens of the United States, even though many of them were born in the United States, and therefore that they had no rights which white people were bound to respect. So it was crucially important to overturn that case. There is this interesting language, and subject to the jurisdiction thereof. What does that mean? Well, the original draft of the Citizenship Clause said, excluding Indians not taxed. That was their rather, that was their 19th century language. And they meant that Native American people who lived on Native American land and didn't pay taxes to the United States were not subject to the jurisdiction of the United States and did not become birthright US citizens. But with that important but relatively limited exception, if you're born or naturalized in the United States, you're a citizen of the United States. Okay, that's the Citizenship Clause. Now let's read the next sentence. No state shall make or enforce any law which shall abridge the privileges or immunities of the United States. That's called the Privileges or Immunities Clause. And there's so much to say about this clause as well. But the big idea here is that there are certain basic civil rights or privileges or immunities that everyone has and that no state can abridge. Why is that such a big idea? Remember what the language of the original Bill of Rights said: Congress shall make no law abridging the freedom of speech. The whole Bill of Rights only prevented Congress from abridging rights. It didn't prevent the states from doing so. This clause, the Privileges or Immunities Clause, says states as well as Congress have to respect basic civil rights or privileges or immunities, including most of the rights of the Bill of Rights. And that meant that the Bill of Rights was incorporated against the states so that the states and the feds had to respect it. And as Kerry's slide shows us, the Bill of Rights protections like free speech apply as much to the president and Congress as they do to the governor or state legislature. And of course, that's very important because if freedom of conscience is a natural right that comes from God or nature, not from government, as James Madison said, then it wouldn't make sense for the governor to have the ability to infringe it, even though the president did not. And that's why Madison's most important amendment, the one he thought was the most important in the bunch, would have prevented the states from abridging freedom of speech and press and trial by jury. That failed, and it took the 14th Amendment to actually incorporate the Bill of Rights against the states. Okay, now let's get to the last clauses, because that's really what we're going to focus on today. Nor shall any state deprive any person of life, liberty, or property without due process of law. There's an interesting shift of language here. The previous clause said, no state can abridge the privileges or immunities of citizens of the United States. This says states can't deprive any persons of life, liberty, or property. A person might not be a citizen. They could be a non-citizen. So there are certain rights that persons, non-citizens and citizens alike, have that even citizens don't have, and that's the right not to be deprived of life, liberty, or property without due process of law. And then we come to the final clause, nor deny to any person within its jurisdiction the equal protection of the law. That's called the Equal Protection Clause, and that's the one we're really going to focus on today, because it's the clause that guarantees equal protection, equality, and it's guaranteed to all persons, citizens and non-citizens alike. So what does equal protection mean? Now, let's pull back for a second and remember that the 14th Amendment was promoted by the fact that the Southern states were passing the infamous Black Codes, which denied African Americans who were free the right to make and enforce contracts, to sue and be sued, to inherit property, to basically exercise the civil rights of white people. And that's why Congress passed the Civil Rights Act of 1866, guaranteeing all those rights. And the main purpose of the 14th Amendment was to ensure that Congress had that power to enforce the Civil Rights Act, which guaranteed to all persons equal protection and to all citizens equal privileges or immunities. And that's why Kerry is showing us Section 5, which says Congress shall have the power to enforce by appropriate legislation the provisions of this article, including the Civil Rights Act of 1866 and the Civil Rights Act of 1875. And now I know we're starting to get a little, it sounds like this is in the weeds, but it's really important, because the Civil Rights Act of 1866 applied to basic rights like the right to make contracts, the right to sue and be sued, and so forth. But then it came to public accommodations. Could a state or could Congress either allow or require segregation in public accommodations? After the 14th Amendment passed, we saw a backlash against Reconstruction, and certain states, in particular in the South, began requiring segregated public accommodations, like requiring African American and white people to sit in separate railroad cars, or to not to deny African Americans the right to go to theaters that white people went to, or to go to restaurants that white people went to. Can you imagine? Can you imagine the indignity after we fought the Civil War to guarantee equality and equal privileges or immunities and equal protection of laws that forced African Americans to be separate from white people? Well, Congress was so concerned about this prospect that it passed the Civil Rights Act of 1875, which would have required equality in places of public accommodation. Astonishingly, the US Supreme Court struck down the Civil Rights Act of 1875 in the infamous civil rights cases, which said that Congress lacked the power to forbid discrimination in basically private places of employment. They're saying a theater or a railroad car is owned by a private company, not the government. Therefore, Congress has no power to ban that discrimination. There was an amazing dissenting opinion by Justice John Marshall Harlan in the civil rights cases. He was a great hero. Kerry, we don't happen to have a picture of Harlan, do we? He's so excited.
No, but I will find one. And I just got one of the few biographies on him. So I'm super excited. This will be my break read.
There are some biographies. They're not, he's still waiting for a really definitive biography, but he was...
Jeff, I was just going to let you know that if you want to put that on your next book list.
Well, I'm not, this is not a Jeff Work book, but I did write a book called, it had an incredibly creative title. It was about the Supreme Court, and it was called The Supreme Court. And it sort of paired different justices. And there's a chapter comparing John Marshall Harlan to Justice Oliver Wendell Holmes. And John Marshall Harlan, I'll tell you this story, when he was writing his dissenting opinion in the civil rights cases, had writer's block. The words wouldn't come. His wife found the inkwell that Chief Justice Roger Taney had used to write the Dred Scott decision. And when he came home from church, she put the inkwell on his desk, and he saw the inkwell, and he was seized by the idea of using Taney's inkwell to efface the stain of illiberalism and inequality that Taney had written into the law on Dred Scott. And as soon as he starts writing, the words just pour out, and he writes this very galvanizing dissent in the civil rights cases. That's hugely important because after the Supreme Court strikes down the Civil Rights Act of 1875, states begin to do exactly what Congress had feared and start to not only allow, but require segregation. That's the real indignity of the railroad segregation involved in Plessy versus Ferguson. Even a railroad company that wanted to allow white people and African Americans to travel together as equals, as they were entitled to do, wasn't allowed to. They were forced to put them into separate cars. And these laws, they're called Jim Crow laws, were challenged in the Plessy versus Ferguson case. And the question there was, can states require railroad companies to have separate cars for African Americans and white people? And before I tell that story, Kerry, let me pause and ask if you have any questions.
Yeah, a couple of the questions are looking at, if Congress is given this extra power in the fifth section of the 14th Amendment, and the courts then look at these cases and say they don't have the power, what are the repercussions for Congress? Could Congress have passed further? And then how much does the court kind of tear away parts of the 14th Amendment with cases like Slaughterhouse case? Because that came from Karen in the chat, and she asked, well, what about the Slaughterhouse case, and how does that strip away power from the 14th Amendment? So that's some questions around the weight of the 14th Amendment. And also one more before we get into this too, were the intentions of the writers of the 14th Amendment to stop things like this from happening? Was that some of the original intention of those great writers?
Just some small questions.
Sorry. That was only the three I had. I had about seven more.
I mean, these are such huge questions. All right, you asked for it. I thought we were going to sort of smoothly get right into Plessy and
well, we need to do Plessy, and I want also to hear more about Plessy, like the fact that there are people in our country that are constantly, even when being pushed back, fighting, and Plessy being one of them. Why does he choose to say, I'm going to take up this fight, I'm going to push the boundaries, and the court cases around it, and how that works to push the law to do what it says it's supposed to do? So all of those things. There you go.
Sounds great. But let me answer your question and Karen's and Colin's about incorporation and Slaughterhouse and all that. Okay, so friends, this is going to be kind of technical, but I know we can do it. So I'm going to try to be clear. Let's see if I do a good job. So the Slaughterhouse cases basically said, they were decided in 1873, and I told you that the purpose of the Privileges or Immunities Clause was to incorporate or apply the Bill of Rights against the states. John Bingham, who wrote the 14th Amendment, he was the James Madison of the 14th Amendment. He was the guy who was mostly responsible for its language. And in a speech in Congress, he stood up and said what he intended. And you rarely have a kind of aha moments where the author of a really totemic constitutional provision tells you what he's trying to do. But he said, I was reading the Barron versus Baltimore case where Chief Justice Marshall said the Bill of Rights didn't apply against the states because it only said Congress shall make no law. And Barron versus Baltimore said, hey, if Congress was supposed to be bound by the Bill of Rights, then the Constitution would have said explicitly, no state shall also abridge these rights. So then Bingham says, I did just what Chief Justice Marshall said. He said you needed language saying no state shall abridge these rights. That's what I did. And I wrote down no state shall abridge the privileges or immunities of citizenship. And that's because I wanted to essentially apply most of the Bill of Rights against the states. I'm simplifying a little bit, but that's the gist of it. Nevertheless, in the Slaughterhouse cases, the Supreme Court completely ignored Bingham's original understanding. We've been talking about originalism and saying that some justices and scholars and students like you believe that the Constitution should be interpreted in light of its original public meaning at the time of ratification. If you're an originalist and you care about what John Bingham, the father of the amendment, thought, as well as what many of the people in Congress who proposed it thought, you'd have to say the purpose was to apply the Bill of Rights against the states. But the Supreme Court completely ignored that in the Slaughterhouse cases, and it construed privileges or immunities of citizenship basically to mean a tiny set of pre-existing rights that were already in the Constitution, like the right to petition government or the right to not have Congress suspend habeas corpus, except in times of emergency and so forth. So basically, it said privileges or immunities are only national rights that are already in the Constitution. They don't include the Bill of Rights, and therefore the Bill of Rights does not incorporate against the states. That was a total evisceration of one of the main purposes of the amendment. It was done so on the grounds of federalism. The court said this will totally change the balance between federal and state power, and therefore we're not going to imagine that that's what Congress and the amendment intended to do. And it took almost 100 years for the Supreme Court to begin to incorporate the Bill of Rights against the states. It started doing that in the 1920s. In the Gitlow case, which applied the First Amendment against the states, in the 1960s, most of the Bill of Rights was incorporated or applied against the states. But the drama, the process continues. Just last year, and in the past few years, the court incorporated the unanimous jury requirement and the Eighth Amendment excessive fines requirement against the states. Today, the only amendments that are not incorporated against the states are the Fifth Amendment's grand jury provisions, the Seventh Amendment civil, the Seventh Amendment's civil jury provisions, and the Third Amendment, prohibition against quartering soldiers in the home. That's it. Everything else has been incorporated, and it's happening as recently as the past 2 years. Okay, so that's incorporation and Slaughterhouse. Had Slaughterhouse come out the other way, then perhaps then Plessy might have come out differently, because as Justice Harlan said in his dissenting opinion in Plessy versus Ferguson, the right of locomotion, the right to travel, the right to engage in the ordinary occupations of life and to go from one state to another using common carriage is itself a fundamental liberty or privilege or immunity of citizenship. The right to be able to travel free from racial discrimination could have been located in the first sentence of the 14th Amendment as one of the basic rights of citizenship of the United States, or in the Privileges or Immunities Clause. But once that's read out of existence, then the court has only two clauses left to consider: the Due Process Clause and the Equal Protection Clause. So now we're going to talk about Plessy. Let me just ask you this. This is kind of a tough question or an easy question, but do you believe that requiring people who are black and white to sit in separate railroad cars violates the Equal Protection Clause or the Due Process Clause? And if so, why? Why does it violate the Equal Protection Clause or the Due Process Clause to require black people and white people to sit in separate railroad cars? Huge question. We'll see if anyone can chat it fast. But this is the central question we have to think about, because a majority of the court said there's no constitutional problem with requiring black and white people to sit in separate railroad cars. That basically, it's just a question of convenience. It's easier to require them. Both people may prefer it. And if there's any offense taken, then that's just because black people are misconstruing it. It's nothing in the law itself, because after all, the facilities are exactly equal. Both black and white people have exactly equal railroad cars that are just as nice. Therefore, there's no violation of equality, and there's certainly no violation of liberty, and therefore we're going to uphold separate but equal. That's what a majority of the court held in an opinion by Justice Brown was his name. Justice John Marshall Harlan dissented, and what I'm asking you is to try to figure out what was the grounds for his dissent? Now, Joan comes up with an extremely excellent suggestion that it violates freedom of association. And of course, in a sense, it does, Joan, because say black and white people who are friends who are traveling together nowadays, who are married together, would be not allowed to associate. The problem technically is that freedom of association really was generally had to do with rights of political association that were being denied by the states, and they didn't include the right to associate in quasi-private places that are not owned by the state. And therefore, it wasn't a completely natural place to locate it, although I think there's no question that you could press this freedom of association claim. Elizabeth Casey says it's a violation because equal protection means equal treatment, and making them sit in different cars, you're treating them differently. That's exactly right, Elizabeth. It does treat people differently, but the court responded to your argument. It said all sorts of laws, discriminate, but as long as the discrimination is even-handed, then there's no unconstitutional discrimination. And here, Black people can't sit with white people, and white people can't sit with Black people. And in that sense, you're not treating people differently. Each race is prohibited with sitting with the other. So therefore, there's no injury or no harm. That was the majority's response. So, Elizabeth, what is the response to what I just said? Because Justice Harlan had a response to that. Where's the inequality if the majority just says both groups are equally affected and therefore neither is treated unequally?
And Kristen in the Q&A added, I would say that the introduction of this precedent, that it presents a slippery slope, like where does it end and who gets to decide what is equal? So I think, and just to kind of like parse this out a little bit more, separate, even if they were perfectly identical, does that still represent equal? And that's really what you have to unpack. One side says, yes, it does. It's equal. That means it's the same. And the other side says the opposite.
And that, Elizabeth, Curry's just responded to you're doing great and you're giving every good response, but you're saying, what if the minority seeing wasn't as nice? And Curry says, well, imagine it was. And of course, Elizabeth, you're right. It wasn't as nice. It
wasn't, yeah.
It's a joke. It was literally laughable to claim that it was as nice because it wasn't. But the court is just giving this hypothetical, imagine that it was. So then we have a really interesting comment from Laura Brown. The enforcement of the laws for equality was easy for the justices because they were men and white. They were also very educated and affluent. They had no idea what it was like to have been enslaved or deal with the hatred and violence of some white people. They had power and did not have firsthand knowledge of what they were doing to people of color. That's a great observation, Laura. And the answer is in your statement. I guess I would say they didn't have firsthand knowledge of what they were doing to people of color. What were they doing to people of color by requiring that people of color sit in different railroad carriages from white people? Because after all, the court is saying there's no inequality. It's just convenience, and there's no problem. And I think the answer,
it's a hard one.
Yes, Laura, exactly. They were stating that people of color were not equal. That is exactly what they were doing. And it picks up on your excellent language earlier about they had no idea what it was like to have been enslaved or deal with the hatred and violence of some people. Far from just tending to the convenience of both races, this segregation is expressing hatred and violence of some white people and stating that people of color are not equal. And that is exactly what Justice Harlan said in his incredible dissenting opinion. And it's amazing that it took so long for the Supreme Court and even for the Brown versus Board of Education decision to state it as clearly as you, Laura, just did, and as Justice Harlan did in his dissenting opinion. He basically said, anyone who claims that this is just for convenience and that the facilities are equal is blinkering reality. And then he gave this immortal words, and I guess I could try to call it up because he'll say it much better than I did. He said, everyone knows that the real purpose of this law, far from just tending to the convenience of both races, was to degrade and stigmatize Black people, to signal, as Laura Brown said, that they're not equal. Everyone knows what the real purpose was. So although the law is formally equal, Black people can't sit with white people can't sit with Black people, everyone knows that the purpose is to stigmatize and degrade them, and that this creates, in America, a system of caste, C-A-S-T-E, caste affirming. In India, if you read the great wisdom traditions, the Bhagavad Gita, you'll read about the caste system where the Brahmins are on top and then there are lower castes below. And in the Congress that passed the 14th Amendment, people stood up and said, this will mean that there's no more caste system in America. There aren't some people on top and some people below. But Harlan, in his Plessy dissent, said, everyone knows that the real purpose was basically to reestablish a caste system by degrading African Americans, stigmatizing them, signaling that they weren't equal. Let me see, I didn't come prepared, but it is, here we go, beautiful. Harlan says,
the Constitution is colorblind?
No, it's the everyone knows language, because it's an amazing dissent, and we're going to actually get a whole bunch of it. But he said right here, he said, everyone knows that the statute in question had its origin in the purpose not so much to exclude white persons from railroad cars occupied by Blacks as to exclude colored people from coaches occupied by or assigned to white persons. So he's saying we can look beyond the formal equality of the law to its actual purpose. And here everyone knows what the real purpose was, which was to exclude colored people, or African Americans, we would say today. This, he's using the language of his time, which is jarring to us. And that this purpose was to stigmatize or degrade them and signal, as Laura Brown said, that they're not equal. And that's his response to Justice Brown's majority opinion, which said that if assignment to the Black-only car doesn't confer a badge of inferiority, because this is true only if the colored race, as Brown, chooses to put that construction upon it. Harlan says it's not a question of who choosing to put that construction. It was obviously the purpose. It was passed by racist white people who thought Black people weren't good enough to sit in the cars with them. So that's just a crucial part of Harlan's ruling. And thank you, Laura, for doing such a great job in distilling it in really clear language. Now we have to go on. I'm going to read one other passage from Harlan's dissent because it's really important, and it's, if we are kind of inspired by Harlan's prescience in recognizing the real purpose of the law, this next passage is a little more jarring.
But I appreciate Jeff kind of showing the whole picture of Harlan, because sometimes we do this thing with history where we kind of only pull up the good things about somebody and say, there's a whole package here and we need to see all sides of people. So as I lead into that, that next section.
We do, because it is, history is complicated, and our job is to learn it all. So Harlan says, the white race deems itself to be the dominant race in this country, and so it is, in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time, if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here, C-A-S-T-E. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. That's an extraordinarily important passage, and let's parse it for a sec. First, this extremely jarring language at the beginning. The white race deems itself to be the dominant race. It is in prestige and achievements in education and wealth and power. I think it'll continue to be if it remains true to its great heritage and holds fast to the principles of constitutional liberty. So for Harlan, there's a difference between civil equality and social equality. This is a distinction we don't recognize today, but even Abraham Lincoln made it, believe it or not. he basically said, I'm not saying that, and Harlan, that African Americans will be socially equal in prestige and education and wealth and power to whites, but everyone has the same civil rights. And in order to maintain their social superiority, white people have to guarantee equal civil rights to everyone. And civil rights include the right to travel on equal terms as everyone else, to make contracts and so forth. So it's a pretty narrow notion of equality. He's not saying that our modern debates about equality, that we're going to end unconscious bias, or that we're going to be truly equal, or that African Americans and whites are going to be truly equal in respect. He's saying we're just entitled to the same civil rights. Why is this hugely important? Because that's what the second part of that sentence goes on to say. He says, famous language, Justice Clarence Thomas likes to quote this language, and so did Justice Thurgood Marshall before he argued Brown versus Board of Education. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. That language of our Constitution is colorblind was invoked both by Thurgood Marshall when he said that separate schools were unconstitutional, and by Justice Thomas when he says that affirmative action is unconstitutional. Justice Thomas is using that to signify government can never take race into account. The government can't ever classify on the basis of race. Any race-based classifications are unconstitutional because our Constitution is colorblind. But that's not what Harlan was saying. He was saying only with respect to classifications involving civil rights, not political rights like voting, or social rights like the right to have equal respect, is the Constitution colorblind. In other areas, the government is free to discriminate against or in favor of people as it pleases. That language, as I said, that debate has totally fallen out today, this idea that it's only this narrow category of civil rights that you're required to be equal. But again, if you're an original understanding conservative, then it's not historically precise or accurate to say that the framers of the 14th Amendment intended the government to be colorblind in all circumstances. They only required colorblindness in respect to civil rights, not political or social rights. All right, we've parsed it, but now we really have a good sense of why. And the reason this is important for Plessy is there was a debate in 1896 about whether or not the right to travel on railroad cars was a civil right or not. Harlan said it was because railroads, although privately owned, were quasi-public accommodations like streetcars or not movies, there weren't movies then, or theaters or other public conveyances. And therefore, the right to travel on quasi-public accommodations, even privately owned, was a civil right. The argument on the other side is that they wasn't. They were just private companies, and therefore innkeepers and theater owners and railroad companies didn't have to act as common carriers. Harlan had the better argument, and it's one that dropped out of the picture in Brown versus Board of Education involving schools, because schools are provided by the state. But that was a technicality that was central to the debate over the Civil Rights Act of 1875, because that did involve theaters, public conveyances, and inns and so forth. And the question of whether or not the right to go to schools is a civil right is going to be crucial for Brown, because
that's my next point. I was like, yeah. Civil rights, schools, and then segregation.
Because now, friends, we've come to the most important case of the 20th century, and that's Brown versus Board of Education. And now that we've looked at Plessy so carefully and looked at the original understanding, I think we're very well set up to ask, why is it that the court held in 1954 in the Brown versus Board of Education case, argued by Thurgood Marshall, which struck down segregated schools, even those that were purportedly separate but equal? Why did the court hold that separate but equal was inherently unequal? That even if the schools had equal facilities, which of course, again, they didn't, as you all just said in the railroad cars example, but let's imagine that they did, why would separate but equal schools be unconstitutional? And Laura, I think, you've already answered it for railroad cars, but tell me again, Laura, why it is that all those states that in the 1950s required African Americans and white people to go to different schools was a violation of equal protection. And actually, Kristen, your comment about Plessy answers the question too. And it's like saying, by definition, the desire to separate implies inequality without actually spelling out. Exactly, beautifully said. And you've recommended the Isabel Wilkerson book, which is a great recommendation, and it would be great to read that and talk about that. And then Laura adds, this caused great trauma to people of color, which has lasting negative impacts of these populations that are still in play today. This is not something laws alone can change. That's true that the stigmatizing effects of these laws enforcing segregation, the caste affirming effects can cause trauma and negative impacts that can't be measured by the laws. Now, Laura, your point about trauma that can't be managed by the law is important because in the Brown majority decision, Chief Justice Earl Warren cited studies done by the sociologist Kenneth Clark involving dolls and young students. And Kenneth Clark found that students, African-American girls who'd grown up in segregated schools, were less likely to be drawn to choose African-American dolls than were African-American girls who'd grown up in integrated settings. And he inferred from this that they had lower self-image, that they'd been traumatized, and therefore that they were not drawn to choose African-American dolls. And Warren used that to support his point that segregation can have effects on students' hearts and minds that can never be fully measured or easily undone. Now, I mention that both because it affirms your insight, Laura, about the trauma that can be caused to people of color by these laws, but also because that footnote was very controversial, and the Southern states were so determined to resist the Brown holding that they held trials, believe it or not, on the accuracy of Kenneth Clark's doll studies. And they said it was methodologically flawed, and therefore the whole decision should be ignored because this footnote, this sociological jurisprudence, they called it, was inaccurate. So I guess I'll go back to you, Laura, and say, would you, do you think the Brown decision would have been less controversial, would have been more powerful if it had simply made your initial point and said, everyone knows that the real point of laws segregating African-American and white school kids was to signal that Black people were unequal? Chief Justice Warren could have said that and not added that footnote about the trauma that the laws the laws cause, the emotional effects on Black people. I wonder if it would have made much of a difference. Probably not, because those Southern states were so determined to resist Brown, it was called massive resistance, they would have resisted it regardless of what the decision said. But this has become a point today because Justice Thomas said that stuff about sociological jurisprudence should have been left out. There shouldn't have been a footnote about the trauma or effects on Black people. Justice Thomas said the problem with Brown was that any laws that classify on the basis of race are unconstitutional because the Constitution is colorblind. Now, I said earlier, I don't think that's a good originalist argument. With great respect to Justice Thomas as an originalist, the framers did not believe that all laws had to be colorblind. They thought only laws involving civil rights, not political or social rights. So the crucial question for an originalist should be, is the right to go to public school a civil right? And that's the question that the court never answered in Brown. It said some people at the time that the 14th Amendment was passed stood up in Congress and said, don't worry, this isn't going to require segregation, desegregation. Others had a different view. Because history's not clear, we're going to focus on the meaning of schools today, and today's schools are so important that it's unthinkable that they not be desegregated. That was a way of eliding the historical argument. But for an originalist, you got to answer the argument, because what are you going to make about the fact that some people stood up in Congress and said, hey, white people, don't worry, this is not going to require us to desegregate the schools. Now, I'm going to share an amazing experience I had. I had one dinner with the late Justice Scalia. A friend had made a bet with him, actually, and he lost the bet, and the bet was, as a result, Justice Scalia had to take the friend out to dinner, and he invited me along. And I was sitting next to Justice Scalia, and we were, he was incredibly funny and expansive, after he was, drinking some good wine. And I finally screwed up my courage and I said, Justice Scalia, I have a question for you. You say you've got to interpret the Constitution in light of its original understanding, but people stood up in Congress that passed the 14th Amendment and said, don't worry, this isn't going to require desegregation. How do you reconcile Brown versus Board of Education with your originalist commitments? He paused for a second, and then he threw back his head and laughed, and he said, you know what? No theory is perfect. So he was basically saying, you know what? This is pretty tricky to justify on originalist grounds. Now, for doubles, triple extra credit, if you want to really dig into this is a big debate. There have been attempts to justify Brown on originalist grounds. They're actually too complicated for me to sum up fast enough, so I'm not going to do it. But start with Michael McConnell's Originalism and the Desegregation Decisions in the Virginia Law Review, and you'll begin to get a sense of it, and then we can talk more about it later if you like. But I've shared all that to just show that, isn't it amazing that the most significant constitutional case of the 20th century, which really everyone agrees is constitutional. You cannot be confirmed to the Supreme Court today if you don't recognize the rightness of Brown, although it's now become some nominees for lower courts are refusing to say whether they think that any cases are correctly decided, including Brown. Every justice on the current Supreme Court believes that Brown was unquestionably right. No one would question it. And yet it's harder to justify as a matter of original understanding than you think, given the number of originalist justices there are. So we now know, based on what we've talked about so far, enough about some of the wrinkles about what, even if education wasn't considered a civil right in when the 14th Amendment was passed, maybe it should be considered a civil right by 1954 because states were providing it to all without discretion. And one definition of a civil right is it's uniform from state to state and available as a matter of right rather than a privilege. So you could say it became a civil right, but that's not anything that the court ever really dug into. Nor did the court clearly say what Laura Brown said at the beginning, which is just everyone knows that the real purpose of segregation was to stigmatize and degrade. Justice Harlan said it, but Chief Justice Warren didn't say it really clearly. And it was a law professor, Charles Black, in his great article on desegregation decisions, who made Laura's point really clearly. He says, anyone who doubts that the real purpose of laws that segregated was to stigmatize and degrade should be met with the sovereign prerogative of philosophers, namely laughter. That's what he said. It is laughable. It is a joke. It is beyond taking seriously that anyone would question Laura Brown's point that the real purpose of these laws was to stigmatize and degrade. It's obvious, but the court didn't say it explicitly. Okay, we got from Plessy to Brown, Kerry. Shall we take a few
we do have to wrap up. We're about 13 minutes over.
Oh, no, I did. I lost track of time. I'm so sorry.
It's totally okay, because I think it's so really important to unpack Brown, because there's so many conversations today are around this. And I can see the chat kind of like blowing up around those questions about, but is color blindness a dangerous thing when applying color blindness in a way that you don't understand people's perspectives, where they're come from and how they're treated? That was a great question in there. We talked about schools being civil. If they are civil rights, then they should be equal from state to state. And we clearly know that public schools are not equal state to state. So there's an unpacking that needs to happen there. But this is what I think is so important about this class, is that these conversations around what the meaning is of the 14th Amendment and equality and under life, liberty, and pursuit of happiness, it really still needs to be understood, worked on, and discussed in so much more time than we have. But what I'd love for you to wrap us up and bring us home, Jeff, is what does the 14th Amendment do in its essential embodiment to the Constitution? How does it change the Constitution? And what does it add to the Constitution that some people call it a second founding? So give us that big picture so now we can go and apply it to other stuff.
Well, it fulfills the promise of the Declaration of Independence. It ensures that all human beings are not only created equal, but have equal rights, in particular, equal protection of the laws. The debate about what equal protection means has led to the most contested questions of our history and of our modern life today. And from affirmative action to voting rights, to LGBTQ rights, to the rights of non-citizens, people disagree strongly about what equal protection means and what equality requires. But now that promise, that shining promise, is inscribed into the Constitution. Lincoln made the promise at Gettysburg. Frederick Douglass made the promise in his speech, "What to a slave is the 4th of July." And King made the promise on the Mall, as we saw last week in that incredibly moving speech in the Civil War Gallery. And now it's up to us, friends, to learn about the history of equality, to learn about the arguments about what it means on both sides, and to make up our own minds.
We might have to add a class just on equal protection. Another one. So thank you so much, Jeff. Thank you, everybody, for the great conversation in the chat today. And yes, we need to all read more about Harlan, about these dissents, about the pieces, and the fascinating work that was done to bring Brown versus Board of Ed to the Supreme Court, because that is, in a nutshell itself, an unbelievable movement of lower court cases and infusing different conversations and arguments into those cases to be able to come to the Supreme Court. And we never, ever forget that those court cases all begin with the people saying, this is not fair, this is not just, these are my freedoms, and then fighting it all the way to the court. So I'd like to end on the image of these two and the work that they did to help define the 14th Amendment. Thank you, Jeff.
Thank you, Kerry. Thanks, friends. We'll see you later this week.